So in the previous lesson, what we did was spend some time talking about the concept of written notice as a process, as a method by which severance can take place. This lesson is going to talk about the next of the major methods by which severance can take place, as per the case of Williams and Hensman, this being the act of operating on your own share. So thus far we've been exploring the different methods of severance in relation to the co-ownership of land. Previously we looked at the process of severance by way of written notice. This lesson, as I've said, we're going to talk about the process of severance by way of operating and acting on your own share. What does it mean to act on your own share, or to operate on your own share? Well, it's essentially the process whereby a joint tenant does something which irrevocably derogates their right in the joint tenancy. So, if you remember back to previous lessons when we talked about the idea of the joint tenancy, and specifically the distinction between a joint tenancy on the one hand and a tenancy in common on the other hand, we noted that what is important to remember is that when you talk about a joint tenancy, all of the co-owners of that property act as a single cohesive unit. They are all joint tenants, and they are joint tenants of the property. But when we think about the tenancy in common, this is really where there is individualized shares. You can divide people up in a tenancy in common, which you couldn't do in a joint tenancy. And so if you act in a way which implies that you are not part of this cohesive unit, then you are implying that you are not part of the joint tenancy. And so by this implication, you can sever your interests. So it is essentially severing through actions, and by severing through actions, what you do is you essentially do what is required for severance, or do what is necessary in the process of severance, which is, of course, becoming a tenancy in common. If you act as if you were a tenancy in common, then you have severed by acting on your own share. So this is really what severance by acting on one's own share refers to. But what kind of acts do we actually require in order for this to operate? What does require to constitute operating on one's own share? Well, there are a number of acts which could be implemented and could be argued to be an act which constitutes severance. The general principle and the common thread that threads all of these acts together is the view that the act itself is irrevocable. Okay, it is something that cannot be reversed, and therefore we can unsever our interests. So, to alienate with a joint tenancy, the party is severing. The party who is severing will simply sell or dispose their rights under a joint tenancy. This is by way of alienating a joint tenancy or alienating with a joint tenancy, alienating your relationship to a joint tenancy. And so as a result of which, what you are doing is you are severing by acting as a tenancy in common. If a joint tenant, for example, enters into a contract to sell their rights, then this will effectively represent severance from a joint tenancy on the basis of their decision. That contract to sell their rights doesn't necessarily have to include a clause or a provision or a point that says this is going to be a severance. You're going to sever your joint tenancy or your interest in the joint tenancy and become a tenancy in common. That's not what this particular thing does. That's not what it represents. Because simply put, the act of selling your rights is by and large and in and of itself something of a severance action, an action of severance. And we can refer back to the 1969 case of the Draper's conveyance that we looked at in the previous lesson. This was the case where an individual had given written notice to sever, and then they changed their mind, and they tried to get the letter that they had given written notice from away from the person to whom the severance was going to be delivered, or the notice was going to be delivered to. Essentially, what we have here is this case simply illustrates that the commencement of litigation against the other joint tenancy could be sufficient to sever on the basis of operating on your own share. So there is an argument, okay, that when you do litigation against somebody, if you go into litigation with a joint tenant, then this could constitute severance by way of operating on your own share, but this could arguably not be irrevocable, since the commencement of litigation does not have to result in an outcome which would constitute a severance. So it sort of challenges the basic conception of acting and operating on one's own share, given the fact that what we have here is an example of something that may not be irrevocable. Note that the general principle of an act which constitutes a severance would be an act which is irrevocable, but this case sort of points in a different direction to an extent. But what the Draper's conveyance shows us is that if there is a prerequisite intention to sever, and this intention was present at the start of the process, then this would be sufficient evidence to show that a severance has taken place, regardless of even if it wasn't necessarily an irrevocable act itself.